All right, we're back. Hello. It's been a bit. I've been busy, but I hope you all had a happy Easter, those of you who celebrate. I hope you had an even better April Fool's. I think everyone here celebrated that one. So, yeah, let's chat for a few minutes, let people get a chance to arrive. Say my hellos to all of you who were kind enough to wait. So, Robert Fortin, Vlad the Impaler, Ali Benny, Troy Funkhauser, good to see you all. And Chili de Con Artist, Chili de Convict, I guess, right now. Glober Mom, Me Too, PDD, Neil Morrison, all the way from Scotland, and Paul from Scotland. Wow. Two whole Scotsmen. At least I hope you're whole Scotsman. But so yeah, hello. Welcome back. Oh, and from all the way in Australia. Good to see you, Robin Jamie Hughes. I guess that's one of the benefits of streaming a little later than I typically do my streams is gives the Aussies a time to show up in the morning. Or I guess what is it? Is it about noon there? So yeah. Am I adding dickbags content, Kevin Campbell? I mean, we're covering the same thing, but 10 a.m. Okay, so I guess one way or another, anytime I stream, it's probably going to be morning in Australia. But yeah. So Mimsy, Dominic, good to see you. So yeah, as you all know, today basically we're going to take a look at our Nevada judges. They did Delete Lawz bail hearing, seeking bail to get out of jail while he's while he's appealing. Well, Kevin Campbell, that somebody was actually me in Dickbags Live, commenting. I just didn't know, yeah. So, Neil Morrison, I haven't seen anything yet on the International Man of Mystery case. Nothing new. Like I said, I'm really hoping it goes to trial, and if it does, I'll absolutely stream it. And Paul Berry, Liz Lizard Breath, good to see you both. But speaking of trials, though, so I'm not committing to it yet. Not committing to it yet, but in just under 2 weeks, Karen Reed's trial should start, assuming it goes. There's always the chance of another delay or a last minute plea deal or something. But so no committing yet, but things are looking good for me to be able to stream that one. And I was hoping Emily D. Baker would give that one a miss, because sometimes she doesn't like criminal trials, but she is streaming it, so I'll be going against the gravitational weight of the Emily D. Baker channel. But either way, it looks like it could be a fun one to do, an interesting one. And so that's the plan. We'll see if the plan holds out, basically. Like I said, there's no guarantees. it's 2 weeks out, but I shouldn't have any distractions. So yeah. But for those of you who are new here, I don't know why you'd be new, but most of you, well, most of my audience is for Delete Lawz content. I try to branch out, but I get most of my views here. So I'm Joe. I'm an attorney licensed to practice in Utah. Today, everything we're talking about is in Nevada, but yeah. So, Linz, good to see you. So I think before we jump into the video from our Nevada judges for the bond hearing, I want to talk a little bit about his appeal. And it's, in a nutshell, I don't see him having a chance in hell of winning on appeal. But at the end of the trial live stream, I talked a little bit about appeal, and I wasn't quite sure the rules in Nevada. I did further research, and so I mentioned here in Utah, from the justice courts, municipal courts, city courts, just like in Nevada, the appeal from that is to district court instead of the Court of Appeals. Well, I mentioned here in Utah, that isn't a true appeal. It's a trial de novo. So basically, you get a second bite at the apple at the district court level. And Don, I almost made that joke. I almost made the joke about him having no appeal, but we're talking about court. So I said I wasn't sure in Nevada if it would be an appeal or if it would be a trial de novo. Well, from the further research I've done, it is an actual appeal to the district court. So no new trial. And so that actually, for those of you who don't like Delete Lawz, that's good news, because if he were granted a new trial, presumably he'd be found guilty once again because he did it. But the district court could give him a new sentence, which, if he behaved in district court, might be a lesser sentence. But it's not. And I've speaking of the de novo trial in district court, so one of my embarrassing court stories. So the firm I used to work at, well, because you have the right to a de novo trial for your appeal of a justice court conviction, you don't get a preliminary hearing in justice court. So my old boss at the firm I used to look at, he'd say, what do you have to lose going to trial in district or in justice court? Treat it like it is the preliminary hearing, except, it's not a reasonable or probable cause standard, which is what it takes to go forward in a preliminary hearing, but it's reasonable doubt standard. So it's a preliminary hearing with higher standards. And, basically you win, it's dismissed. If you lose, you go to trial. So he said, treat it like a preliminary hearing. Well, I was in a justice court way too early in the morning, and trying to get it dismissed because, well, it was a DV case, and the spouse had invoked spousal privilege. So we knew that if it went to trial, it would be dismissed on the day of trial. It's just a game of chicken going up to trial. But the prosecutor was a dickhead. He just would not give me discovery. So finally, I'm in court. Judge, just dismiss it. They're playing games. They're not giving us discovery. We can't work if we don't have the discovery. And the judge said, "Oh, well, do a written motion, whatever. But what are we doing now?" And it being way too early in the morning, I say, "Well, let's just put it to preliminary hearing." The judge, scratches his chin. "I believe we're in justice court where we don't have preliminary hearings." And I'm oh shit. I meant set it for trial. It's too early. I haven't had my caffeine yet. Whereas in my mind, I'm thinking, yeah, your trial is my preliminary hearing. But story time aside, so for his appeal, what grounds for appeal does he have? Well, according to his jail phone calls, the jail live streams, not quite of the quality of Martin Luther King's letters from jail, he thinks that Michael Mee did him dirty, was a terrible attorney, and he's going to get it overturned on ineffective assistance of counsel. Well, he's not. And here's why. While we didn't necessarily agree with Michael Mee's arguments, he did a competent job. Now, he's constrained by court rules and he can't make frivolous arguments. But he still made the arguments Delete Lawz wanted. He tried to argue First Amendment constitutionality. He tried to argue, hey, he moved back. What more did you want? And Delete Lawz, was fuming that Michael Mee didn't introduce his video. He just used the body cam video from Officer Bork. Well, here's the thing. It's the attorney's discretion how they put on the case, as long as they do it competently. And the reality is that Officer Bork's body cam, well, any video of it hurts Delete Lawz. All of the video hurts him. But the body camera is better for him than his video. And here's why. His video, you can't see his feet. You can't see the lines on the ground. You can't see him backing up. The body camera is the video that shows that he initially moved back a couple feet, but then refused to back up more. And his video, you can hear him better, and longer. So he seems like more of a jerk in his video. So the reality is the body camera video, while still damning, was the least bad video. So that was actually a good decision by Michael Mee. And as Paul of Scotland has said, Delete Lawz was supposed to meet with his attorney an hour before court, and he didn't. So they missed out on that opportunity to prepare. Now, of course, I have a feeling, you don't wait until an hour before trial to prepare. You should have prepared beforehand. But it's just, simply put, Michael Mee did a competent, if not overwhelming, job in representing him. So, yeah, but that leaves as his options for appeal constitutional grounds. So basically, mistake of law or abuse of discretion, or the judge letting in evidence that she shouldn't have. But for that, the defense would have had to preserve the objection or have lost a pretrial motion to keep that evidence out. I'm unaware of any of those motions, but I mean, the only real evidence was Officer Bork's testimony and the body camera, and the body camera was coming in regardless. So it was all coming in. So there's no evidentiary problems. There's no constitutional problems because he was arrested for interfering and obstruction. He wasn't arrested for filming. So there is no constitutional problem. The factual issues, well, yeah, the judge gets to make the factual decision in a bench trial, and the appeal is not going to overturn the factual determination. So all we have is abuse of discretion, and the judge went with the midpoint of the allowed maximum sentence. So that how can the midpoint of the legislative maximum, how can that be abuse of discretion? Now, it's certainly more than most judges probably would have given most defendants, but his behavior, he earned it. So there's no abuse of discretion. So I mean, we'll see. His appeals attorney is going to bring up, well, there's serious constitutional issues, and there just isn't. So he's going to be wasting a whole lot of his subscribers' money on an appeal that is bound to lose. There's just no way for him to win. And Gia, thank you. I agree. Corgi's rule. Menchie says hello to Zoe. For those of you who don't know, Menchie is my brother's corgi. He thinks this is his vacation home. So yeah, that's basically where the appeal stands. Is he's going to lose, and he's going to waste a lot of money and time. And great, I hope the appeal is filmed. I don't know. I was going to talk about the Court of Appeals, but no, it's not the Court of Appeals. We've already discussed. It's the district court, and it's in front of Judge Leavitt, who is a legend, an absolute legend, because Judge Leavitt was the judge in the Kim Blandino trial. She was a judge for parts of the Michael McDonald saga. She was the judge when that drunk lawyer appeared in court after a DUI car accident, and she breathalyzed him. And yeah, it was fun. So it should be really fun having Delete Lawz in front of Judge Leavitt. And Judge Levitt, according to our Nevada judges, has never turned down a live stream. So the appeal might actually be live streamed instead of taped and restreamed later on. So it should be fun. And Mr. B asks a good question. Does a successful appeal mean a new trial? And if he gets a new trial and is convicted, could he get the full 12 months in jail, less time served? Yes. Yeah. So basically, an appeal would not, like a successful appeal wouldn't have him declared innocent or not guilty. It would overturn the verdict and send it back to the lower court, to the justice court, to hold a new trial consistent with the findings of the Court of Appeals. So if the Court of Appeals said, you know what, this was an illegal arrest because whatever, filming in fact is a constitutional shield. Well, then it would be remanded back to justice court, and then it would be dismissed because they wouldn't be able to proceed. But if they said, well, it was ineffective assistance of counsel, which it wasn't, but it was ineffective assistance of counsel, so back to the justice court, new trial, and then, new trial. But that's not going to happen. I really don't see it. So yeah. But and in theory, if it were reversed, he could be sentenced higher. It's really unlikely that he would receive a larger sentence. I don't see the same judge, if it were remanded, giving him a lower sentence either. So, and I'm not even going to attempt your last name, but the problem for Michael Mee was he took the case. And I've mentioned before, I don't know if I mentioned it on my channel, but in comments to other people, I've said, I wouldn't have a fundamental, objection to representing First Amendment auditors in their criminal cases, because frankly, this is petty stuff. It's not the crime of the century, but I would really hesitate taking any of them as a client, just because there's a lot more for me to lose, because you take an unwinnable case, and when you don't win it, they demand a refund. They go on YouTube spouting nonsense about you, and you're an incompetent lawyer, you blah blah blah. The appeals lawyer, Mr. Orem, I believe, he's death penalty certified. He is an actual good attorney, but he doesn't get him out on appeal. And Delete Lawz sycophants are, he's incompetent. He should practically be disbarred. He stole Chili's money, and it's a no-win situation for attorneys. And for Michael Mee, it's doubly bad because as of now, he's still representing Delete Lawz in the civil case. And frankly, if I'm Michael Mee, I already have my motion to withdraw. It's at least prepared, if not already filed, because there's a conflict now. Delete Lawz is saying he's incompetent, and trying to use him as his appeal. And that, to me, that's a conflict. That's a conflict. I I I I have to be off all of his cases immediately. So I haven't seen anything filed yet along those lines, but Mr. Me should at least have it drafted. And A-Line is an idiot. Just plain and simple, he's an idiot. So, yeah. From what little I've seen, he is a complete moron, doesn't know what he's talking about. But apparently he's going to, take Delete Lawz as his apprentice to do the no law school bar program. And I don't think they, he says, oh, I'm tutoring him on the law. And it's like, no, it has to be a full-time internship, basically. You're not doing anything for him at the moment. And Kevin, that is a very good point. There is an order denying the motion to recuse the judge in the civil case. And that is on today's agenda, assuming we get there. Because today's agenda, we're going to watch our Nevada judge's motion for bond. Then we're going to look at LVMPD's reply on their motion to dismiss. So we're way behind on that, but I haven't forgotten about it. And then we'll take a look at the order denying the motion to recuse. And so, Dave, thank you very much for the super chat. And any lawyer handling his cases that you're trying to make chicken salad out of chicken poop. You can. The builder is only so good as his tools, as his materials. I can't make a castle out of twigs. It just isn't going to work. So, and Brandon, lucky for you, I'm long-winded, so all we've done so far is talk about his chances of appeal, and long story short, there are no chances. It's going to be a waste of time and money, but it should entertain us because Judge Leavitt doesn't suffer fools, and she's got a big fool coming in July, I think. And as Gia mentioned, May 1st, God, he loses one thing on April Fool's Day, and then May Day is his whatever hearing, pre-trial for the new case. So that should be fun. That should be fun. And was there a new Lauren De Laguna live covering this nonsense? I noticed I initially set this stream for 5:30 my time, but right after I set that, I noticed that Artie was debating that more on that's the caretaker for Delete Lawz channel while he's in jail, and didn't want to run up against that. So I delayed it half an hour, and then Artie got right off. So, yeah. But with that said, let's jump into the video, look at the brilliant acting, Oscar worthy. That, you know, this amazing fake crying is clearly what got Delete Lawz casted as the Black Power Ranger temporarily.
And the Honorable Judge Zimmerman presiding. Please be seated. Come to order.
All right, Jose Decastro, 23CR013015.
Good morning.
Good morning.
Chris Dorm on behalf of Mr. Decastro. He's present.
Nice to see you, Chris. Good morning.
Good morning, Agnes Hotel, State Farm number 11064.
All right, this is your motion.
Yes, Your Honor. First of all, I've had a chance to watch the video of the trial. I watched Mr. Decastro come into the courtroom in an extraordinarily disrespectful fashion and refer to the marshal in the most inappropriate way. I then saw some other things that I consider very poor in the courtroom. And Mr. Decastro was convicted. He was given 6 months in jail. One thing I know he's going to do today is, for no other purpose, no matter what your ruling is, he wants to say sorry. I've asked him if he'd say sorry to the court. I understand that you may see it as that he should have apologized to the marshal. I don't see the marshal in here that he did this. One thing I would note for the court is that the issues that I saw seem to be significant constitutional issues. The court addressed it, but what I did notice is that this should have been really briefed beforehand on First Amendment issues. So the court.
No. And Hank, thank you for joining. No. Well, first off, no. It's not a First Amendment issue. It's, was he interfering in a traffic stop? Holding a camera isn't a shield from other charges. Him, you know, it should have been briefed on constitutional issues. Well, is that the ineffective assistance of counsel you're trying to do? He brought up the First Amendment defense in trial. It didn't work, but it was brought up as a defense. But he seems to think that there should have been a motion in limine, basically saying, hey, you can't bring this evidence because it's First Amendment or a declaratory judgment. It's nonsense. Once again, this isn't a First Amendment issue. So
Had that's your fault. I think it just should have been done beforehand. I also noticed that at time of sentencing, the state asked for a suspended sentence, but Mr. Castro just pushed it. And I see reasonably agitated and irritated the court into causing a sentence that is now 6 months. This man, from what I can tell, Your Honor, has no prior felony convictions whatsoever. I'm doing that upon information and belief. I haven't.
So upon information and belief, it's, my client has told me he has no felony convictions. Well, I mean, other than, you know, the sealed diversion for GHB, allegedly, but, you know, is that a conviction? He had to plead guilty for it, but might not be showing up on his record, other than, you know, the judge in Massachusetts being able to bring it up. So the thing is, though, once again, he's no prior felonies. Well, he was sentenced for his conduct in this case. There's no presumption that only previous felons can be sentenced to jail. It's the judge has allowed, the Nevada state legislature has said for Class B felonies, or Class B misdemeanors, the judge, within their discretion, can sentence up to 6 months in jail each. The judge only went half of that. And he's right. He is right. The state asked for a suspended sentence and a fine. The judge is not bound by that recommendation. She's free to do whatever, even if it had been a plea deal. Now, in some jurisdictions, he could have backed out of that plea deal and gone to trial if she sentenced more, but this wasn't a plea deal. So, yeah. And 65 CJ5, thank you very much. And yeah, the First Amendment, you have a right to be a serial pest. You just don't have a right to interfere in traffic stops. You know, they're like, as long as the serial pestering isn't criminal activity, you have that right. But if there is a criminal statute that otherwise bars that conduct, then you can't. So, but yeah, so some of Delete Lawz idiots, I think it was in the comments section on our Nevada judges, they were lambasting Judge Zimmerman. They thought that this was just a sentencing. They said, well, he took the plea deal for a $500 fine and a suspended sentence, and she gave him 6 months. That's illegal. And because he took the plea deal. This was just the sentencing on the plea deal. And it's like, did you not watch the trial right before that plea deal, or right before that sentencing? Why did they have the officer testifying? Why did they have closing arguments? Why? It was a trial. But his morons, in order to make him look good, that tyrant judge didn't go along with the plea deal. But once again, even if it were a plea deal, the judge isn't bound by the plea deal. The judge isn't bound by the plea deal. But like I said, in some jurisdictions, and these are what I call good jurisdictions, you can back out of the plea deal and go to trial if you're sentenced higher than you expected, because, you know, you're not receiving the benefit of the deal. So, but then, you know, there are plea deals where, hey, you can't back out. See, e.g., Alec Murdaugh, who, you know, his plea deal in federal court was, you give us all the information and you give it to us honestly. And if you don't, then we get to back out, but you can't. So, yeah. You know, but either way. And Troy Funkhauser, thank you very much for the super chat. So, yeah, I thought I had another point, but I don't. So let's go back to the video.
Run the scope. I know the state could do that, but I don't see that he has any felony convictions. He's made his appearances, and I think the time in jail has been shocking to him. I know it has, because I can tell the reaction of the calls every day and how difficult it is for him. I think he pushed this and is learning a very, very difficult lesson in life. I would ask the court to consider, based upon his ties to the community, sister here, nephew, he has a whole bunch of people who wanted to come to court, which I suggested maybe a very, you know, if they're going to come here, be respectful and mindful of what's already occurred in this court. But what I asked the court to do, given his lack of
And he mentions his family ties in Nevada. My understanding, once again, I don't have personal knowledge of this, but my understanding is his sister doesn't like him. So that's not exactly a family tie. Of course, you know, she likes Charlie enough to let Charlie hang out in the backyard while Delete Lawz is in the dog cage, dog pound.
Any serious criminal history, his remorse for his behavior in this courtroom during that trial, and the fact that the state at the time did not want jail time. As I'd asked.
Oh, okay. Kevin. So my grandmother was named Verna. She was named after her uncle Vern. And she hated that. She hated that she was named after her uncle. So my cousin had a kid like days after my grandma died. We're talking his wife didn't drive down from Idaho with him for the funeral because she was about ready to pop. And I tried to convince him to name his new son Vern after our grandma. Although, of course, you know, the kid could say, yeah, I was named after my great uncle. But alas, my attempt at humor was not accepted.
For an appeal bond, Your Honor, so that the issue can be, these issues can be properly raised. And so with that, Your Honor, I asked for an OR. I would just say a reasonable bail. I would suggest that since he came to the trial, since he already has gotten a taste of what inappropriate behavior in a courtroom looks like and feels like, I would ask for a bail in the amount of $10,000 or $20,000, appeal bond in the amount of $10,000 or $20,000. With that,
so he wants a PR bond. So basically, it's let him out for free, even though he's already been convicted. And then if he, you know, breaks his bond conditions, then you can charge him $10,000 or $20,000. The problem is, the minute he's let out, he's gone. You know, that sister that hates him, she's not keeping him in Nevada. He's gone. He doesn't like jail. He doesn't care about the appeal. He is gone. And C65 CJ5, thank you once again. And feelings. He hurt her feelings. The judge's hairdresser's brother's friend's landscaper's sister once dated a cop. That's too close of a tie. How could she not find him guilty when, you know, there's that close of a relationship? Now, of course, you know, in the prison calls from the Birmingham jail, he's, you know, Judge Zimmerman, she's a no good copsucker. Her husband's a cop, and apparently, according to her LinkedIn, her husband is actually a civil rights attorney. I bet that really sticks in his craw, because Delete Lawz likes to think that he is the civil rights attorney in this relationship. But it's Judge Zimmerman's husband that's the civil rights attorney. He's doing what Delete Lawz claims to do. And that really amuses me. It really does. So, yeah. And that's it. They don't share the same last name. His last name is Langford, which, funny enough, I haven't seen him in quite a while, but I know a criminal defense attorney here in Salt Lake by the last name of Langford, and he's quite a good one. You know, I've mentioned, you know, with the Park City case, you know, Sky Lazaro, great attorney. I'd absolutely hire her if I needed one. I'd also hire Mr. Langford. He's wonderful. So, and that's it. Delete Lawz is an uncivil rights attorney. He's the anti-attorney. His help got DUI Debbie weeks, if not months, in jail that she didn't have to, just for obstruction based on his nonsense. So he's the uncivil rights attorney, the anti-attorney. He's the antimatter of the legal world. So yeah. And yes, Kova 42, that Sky Lazaro. And I can't remember if I've ever met her. I think I ran across her in law school. Like, she may have spoken to one of my classes, but I can't remember. We definitely have mutual friends, though. So back to it, though.
Your Honor, may I respond orally? Typically, pursuant to the Nevada rules of criminal practice, the state has 10 days to file an opposition, but this was placed on calendar very quickly. So I would ask for leave of the court to answer orally.
Okay.
Your Honor, I'm in receipt of Mr. Orum's motion for bail or any alternative for his own recognizance release. I would note that NRS 178.488 does make it discretionary upon this court whether you would allow bail pending appeal. Mr. Decastro, there has been a briefing schedule set before Judge Levitt in district court on the appeal, but it's not set to be heard until July. It's discretionary, Your Honor, as with a lot of the bail settings in Nevada, it's discretionary. And the state will oppose this court setting a bail at this point. There seems to be this assumption.
Such acting. I mean, ladies and gentlemen, you're alpha male. I mean, I don't buy into the alpha male nonsense. If that weren't nonsense, I'd never claim to be an alpha male. I came to the conclusion that I'd probably be a pi male because, pi being 3.14, and I have slightly more than 3.14 of my major appendages, but closer to 3 1/4, we'll say. But I disagree with Law Talk with Mike. I think showing emotions is perfectly fine. It's a normal human condition. But when you yell and scream and pound your table, I'm an alpha male, then you get made fun of for such bad acting in court that, that's not alpha. What would Andrew Tate say?
That this court sentenced Mr. Decastro to 6 months in the Clark County Detention Center just because of his conduct or his inappropriate conduct in court. I would venture to say that Your Honor presided over the trial where you found guilt beyond a reasonable doubt for both the obstructing a police officer and resisting a police officer. You saw his conduct in the body-worn camera by the officer. And I would venture to say, and I would submit to the court, that the 6-month sentence that you imposed isn't simply for his behavior in court or his behavior to your marshals, but that it is an appropriate sentence placed upon the defendant by the court due to the charges and the evidence that you saw during trial. There's also been this claim that Mr. Decastro has stayed trouble-free for most of his life. I would venture to say, yes, he does not have felony convictions. He does not have gross misdemeanor convictions, but he does have pretty consistent contact with law enforcement. He does have a warrant out of Ohio for a trespass. And I understand that's a piddly misdemeanor. However, it is a current status. And he has a pending case in Las Vegas Justice Court for the very same offenses that the court heard during the trial here. As to the claim that, hey, there were issues before trial, and there could have been First Amendment issues raised or briefed prior to, Your Honor, defense counsel was able to argue the First Amendment defense. Your Honor heard these arguments both during the trial and during closing arguments.
Hey, that's the exact argument I made just a few minutes ago. I haven't even watched this, but that's the argument I just made. Hey, you say it should have been briefed before trial. He argued it in trial. The judge heard the argument. She disagreed with the argument. So you wanted her to disagree with your argument before trial, is what you're saying. And therefore, you need a new trial for him to make that argument and for her to disagree with that argument before trial. And then be found guilty once again. No, it doesn't work that way.
Mr. Decastro, when he took the stand, raised them as a defense, but Your Honor held, after listening to all of the evidence and applying the law, or found him guilty regardless. This was not a First Amendment issue. The state stands by that. This was simply the defendant breaking the law, and he was sentenced accordingly for his behavior. It was a conduct, it was a consequence, an appropriate sentence imposed by the court to the defendant. And so we would oppose any kind of change or any kind of bail setting or an OR at this point. This is not a pretrial detention. This is not a pretrial, as Valdez-Jimenez was cited also in defense counsel.
Okay, and before she talks about Valdez-Jimenez, so I don't have the bail motion up on my computer, but I saw it on the Dick Bag Patrol live stream a couple days ago. I was in the live chat. The Mr. Oram cited Valdez-Jimenez as, bail is presumed, basically, is what that case says. You're presumptively entitled to bail, but that's pretrial bail. That case does not apply for post-conviction bail for appeal purposes. It's the discretion of the court. And frankly, one of the issues that the court should look at in determining bail, in determining whether a sentence should be suspended pending bail, is the likelihood of the appeal being successful, or even if there's any likelihood of the appeal being successful. Here, it's not going to be successful. There is no likelihood, so why give him bail? Why give him the chance to flee?
Motion. Valdez-Jimenez stands for pretrial detention. Mr. Decastro is no longer cloaked with the presumption of innocence. He has been found guilty beyond a reasonable doubt by Your Honor. And so at this point, I would ask that the 6 months sentence that you imposed stand and that he remain in custody.
Mayor.
Can I ask the interpreter to quit reading? Thank you.
Yes.
So the interpreter over there, yeah, Merrick speaking.
Oh, I was talking about the
Oh, I'm
Polish
sorry.
interpreter. Yes, go ahead.
Your Honor, the statute we cited is, in fact, just discretionary to you to determine on appeal, pending appeal, whether a bit of appeal bond can be issued. I hear the state, I recognize that you found him guilty. I'm not trying to in any way argue that. On appeal, there are legitimate issues. The court can see that, there are some First Amendment issues just from watching the video, things that a court could consider
No, there are.
on appeal. And so that's the only basis I'm bringing that up on. But given the fact that I think he really is contrite for what he's done.
I disagree. Have you watched the videos that have been posted since he's been incarcerated?
I'm in a murder trial.
Okay, so,
So I had a chance.
so he's gonna apologize to me in a minute, but that's not what he's saying on what he's publishing online in his phone calls from the jail. That's not what he's saying at all. And are you aware that he has a trial pending in Las Vegas Municipal Court? He has a case pending in Good Springs Justice Court, where he continues to manufacture situations where he
Wait. What's the Good Springs Justice Court? What's the Good Springs Justice Court? Inquiring minds want to know. Wow. I legitimately didn't know about that one. Oh, okay. The one where he made the U-turn on the highway to go confront the cops on the side of the highway. I got it. I know that one. So never mind. I do know that one. But yeah, he can apologize all he wants in court, but when he's in jail breaking the rules, making third-party phone calls, which he says, well, I didn't know it was against the rules, even though you've got a sign that you received the jail handbook. But he's in jail making phone calls about the judge and the prosecutor and the police and how awful they are and how, vengeance shall be mine. But, I'll go to court and I'll be real contrite because, I'm so sorry. Can't you see these dry-eyed tears? I'm sorry. It's South Park, the Cthulhu trilogy with the BP CEO. Sorry, we're sorry. It just doesn't ring true. Sorry.
get arrested.
Your Honor, I recognize that's what he was sort of doing for a living, and this is, he's now being incarcerated.
Right.
And
So what he's saying, and
It's what he does for a living. So he commits crime for a living. He's a career criminal. Is that what you're saying? That doesn't sound like a very good excuse to me.
a couple of weeks since he's been incarcerated, when he calls from the jail and publishes them on his website, is not what he's about to say to me. Okay, so he's gonna apologize to me now, but that's not what he's doing publicly, okay?
yes, Your Honor, I hear that. I won't have him speak at this time, but I would still ask you to consider that there may be legitimate issues. I think there are for Judge Levitt to consider, and I think these are sort of issues of first impression. That was the other thing I saw, is that in the state of Nevada, I can't find any case law that specifically talks about this filming of police officers.
That's because it's not about filming police officers. It's about interference. It's about being on the scene. It's about interacting with the detained driver. It's about not backing up. It's not about filming. The Officer Bork said, you can keep filming. That's no problem. So you say you can't find any case law on it, but that's not even the issue. It's not the issue. I mean, I realize he's really trying to earn his 25 grand retainer here, but that's not the issue. This is disingenuous.
Say to the court is I recognize that it's obnoxious behavior. That's what it appears to be. Whether it's protected is another thing that I think higher courts need to look at.
I thought of that.
I can see
too.
if the court has already made up the court's mind.
Well, I want to be clear, I did not have a problem with him filming, and I said that when I sentenced him. That was not the issue. It was the safety issues that he created with his behavior. And I also did not sentence him because of his ridiculous behavior in court. That wasn't why I sentenced him to jail. I sentenced him because I found him guilty beyond reasonable doubt, and I thought that was the appropriate sentence. I could have given him 180 days on each count and ran it consecutive for a year in jail, but I didn't. And his behavior was unacceptable in court, but that's not what I sentenced him for. I did not sentence him for his behavior in court. I sentenced him for his behavior for the 2 charges that he faced.
Exactly. It's he interfered and then he resisted arrest. Obstruction and resistance. Not filming. It's not a First Amendment issue.
Yeah, sure.
All right, so your motion is denied. Thank you.
Thank you.
All right. Well, that was, as you know, amazing acting from Delete Lawz. Just absolute top notch. I can't believe he hasn't been nominated for an Oscar yet for it. Or I guess that would be an Emmy. Primetime Emmy. He deserves it. He needs it. One of my law school classmates has an Emmy, by the way. But yeah, he basically does not deserve. He's not entitled to bail. That's a good question. Do the Razzies include streaming platforms now? Well, I assume, when you say streaming platforms, I absolutely assume the Razzies include Netflix and Prime and stuff, Disney. But whether or not they include YouTube, I doubt. But, there's the Webbies and stuff like that. But, yeah. So, yeah. So, don't pee in the pooper. I think it's even more important, of course, not to poop in the pisser, but, that's just me. But that said, let's scurry on and switch tabs. And I know that doesn't look like I switched tabs, but I switched the way it was presented. And let's go from criminal court all the way to federal civil court. And that really is the ultimate freedom, isn't it, Anacito Maldonado? Being able to poop wherever and whenever you want, and with whomever you want, I think is the most important part. And Gia, thank you very much. Gia brings up an excellent point. He's being sued in civil court for a car accident in 2022 with bad injuries, and he was filming his ridiculous video dressed as a cop. So, yeah, he does have that. Of course, presumably that's going to be 2 insurance companies fighting it out, or, at least his insurance company should be fighting it on his behalf, assuming, of course, he has insurance. We're assuming he has insurance, and we're assuming he wasn't doing something that would void that insurance, because, if he's filming, there could be problems. I'm not saying there are problems. I'm just saying there could be problems. Driving while filming might cause problems with his insurance covering it. if he's parked and filming and causes, well, he should have professional liability coverage, basically, if he's filming on a public street and, you know, have the permits close off the street and all that stuff. So he might not have insurance to cover it. I don't know. I don't know the details, but either way, it's probably not a super exciting case to cover. But either way, it is nice to know that he's not the plaintiff in every civil suit he's involved with. And yeah, PDocs has the documents. PDocs has all the documents. So, you know, show them love, support. They're great. And that's it. You can't arrest me. I'm filming. You know, I can kill whoever I want so long as I film it. That's auditor logic. It's terrible logic. And so are you being facetious here, Benjamin Cano, or did James Cameron really not get permits or insurance? And, you know, I'm just saying it's best practices. You know, I hope James Cameron, you know, insured the Titanic, because, you know, the White Star Line certainly didn't appropriately. But yeah, so either way, as I said, we are back in Vegas for the long forgotten, or at least postponed, Delete Lawz, Decastro versus LVMPD. And so last time we were here, remember we had the, well, let's find it. Either way, we had a new motion to dismiss. So basically, here's the procedure. He had his initial complaint. He did his first amended complaint. LVMPD got most of the lawsuit dismissed with prejudice, but he still brought all of those claims back in the second amended complaint, even though he couldn't, but he's certainly trying. And speak of the devil, there's PDocs. Everyone say hi, PDocs. So LVMPD, after the second amended complaint, did a new motion to dismiss, or in the alternative, motion for summary judgment. And Delete Lawz lost his shit. Well, I don't know what I'm supposed to do in here. You know, am I supposed to defend the motion to dismiss or the motion for summary judgment? And it's like, it's brought in the alternative. You defend both. And so he hired Michael Mee, you know, notice of appearance on January 10th. And as I mentioned, he should have a motion to withdraw because there's conflict there. So the yeah. So once Michael Mee was hired on this civil case, he got an extension of time. They did their response, their opposition to the motion to dismiss, or in the alternative, motion for summary judgment. So what we have today is the reply. So remember, you could have the motion, opposition, reply, and then in some instances, a surreply, or, you know, on and on. And then, of course, there's the notice of manual filing. We don't need to worry about that. That's flash drive. That's evidence. We don't get to see what's on the flash drive, so we don't need to worry about that. But then we also have long overdue the order denying docket number 50, motion to recuse. So basically, way back in the annals of time, November 14th, Delete Lawz moved to recuse Judge Gordon. What's his name? Basically saying you ruled against me. That means you're biased, and you've got to step down. You've got to leave. You can't be on my case because you ruled against me. And that's bias and that's illegal. So get the hell out. And the judge said no, because frankly, no, it's not inappropriate bias. You've got to rule against one of the parties. The judge can't just say, well, I don't know. What do you guys think? Someone wins and someone loses every motion. Or at least every part of a motion. So, yeah. But that said, let's get into the reply, because it's nice and long, but luckily, it's not written by Delete Lawz or Michael Me. So, despite it being relatively long, we'll get through it quicker than the Delete Lawz motion of similar length. I am told this was not written by Craig Anderson. It was written by his associate, and that it's amazing. And I realize I'm 2 months late on it, but 2 months late is better than nothing. And so let's do this one. So, defendants, Las Vegas Metropolitan Police Department, LVMPD, and the officers, by and through their attorneys of record, Marquis Auerbach, hereby filed their reply in support of motion to dismiss plaintiff's second amended complaint, or, in the alternative, motion for summary judgment. This reply is made and based upon the pleadings and papers on file herein, the memorandum of points and authorities attached hereto, and any oral argument allowed by counsel at the time of hearing. And as you've heard me complain in the Gurley's case, the Janet versus the Gurleys, I hate when they separate the motion from the memorandum in support of the motion. And hey, wouldn't you know, they don't do it in Vegas. So I like that. And luckily, 65 CJ5, 2 months late for me is not. It's just a pregnant pause, not a pregnancy, because no uterus here. So, introduction. This is a Section 1983 wrongful arrest and excessive force lawsuit. On March 15th, 2023, how is that over a year ago? Defendant Brandon Bork arrested plaintiff Jose Decastro for obstructing a lawful traffic stop when he approached the detainee of the traffic stop and subsequently refused to comply with Officer Bork's commands to move away from the detainee. After Decastro filed his first amended complaint, the defendants moved to dismiss all of Decastro's claims except his excessive force claim. On October 23rd, 2023, this court issued its order granting, in part, defendant's motion to dismiss and granting Decastro leave to amend certain claims. Decastro amended and filed his second amended complaint on November 11th, 2023. The defendants have moved to dismiss all Decastro's claims pursuant to Federal Rule of Civil Procedure 12b-6, or, in the alternative, summary judgment pursuant to Rule 56. And remember, 12b-6 is the motion to dismiss for failure to state a claim upon which relief can be granted. We've seen that many times. And Rule 56 is the rule for summary judgment. And free hat, not free chili, it's free hat, since we've been quoting South Park earlier. But I don't know why I always go through the docket when, I could just wait and, read out the summary of the docket provided by the defendants. In the instant motion to dismiss plaintiff's second amended complaint, or in the alternative motion for summary judgment, defendants requested that the court consider the defendant's officer's body-worn camera footage from the subject incident and Decastro's own video recording pursuant to the incorporation by reference doctrine. The videos established that the officers acted constitutionally and did not violate any of Decastro's federal law or state law rights. However, in plaintiff's response and opposition to the motion, Decastro contests the authenticity of the video evidence. As a result, the incorporation by reference doctrine does not apply, and the instant motion must be adjudicated pursuant to Federal Rule of Civil Procedure 56. Statement of facts. Defendants hereby incorporate the statement of facts and procedural history as recited in the motion. The factual background set forth in Decastro's opposition recounts allegations from the second amended complaint. However, defendant's motion is premised upon the court taking into account the body-worn camera footage of the subject incident. The body-worn camera footage demonstrates that the majority of pertinent allegations in the second amended complaint are demonstrably false. You could say dunce cap in a motion. It might not help you in a motion, but I mean, you could. If it's relevant, I would. But, so as demonstrated by video evidence, all of Decastro's claims lack merit and were brought in bad faith, especially the ones he rebrought that were, dismissed with prejudice. And Ruben Mora, unlike Delete Lawz, I don't tend to block people. People are free to speak on my channel, but you are not free to spam on my channel. So come up with something original, don't spam, or you will be blocked. As demonstrated, let's see. So Decastro recently admitted as much in a video posted on his own YouTube channel, in which he asserted that he successfully baited Officer Bork into arresting him and wants a 7-figure payout from LVMPD. And that's hilarious. And Ruben Mora, you were warned. So bye-bye. In the same video, Decastro professes that he intentionally derogates and degrades police officers in the course and scope of their duties, and likes to do so at a distance intended to induce the officer into ordering Decastro to move back, so that he can refuse such orders. In the video, Decastro submits that he does not set up to audit police within 10 feet, but rather stands about 14 to 18 feet away from the officer. In this case, however, Decastro placed himself well within 10 feet of the detained driver and refused to move back when commanded to by Officer Bork. And so we mentioned during the trial live stream, the standard U.S. parking space is 18 feet long by 9 feet wide. Handicapped spots are slightly wider. So, fun fact, I tend to, legally park in the handicapped spots, but it's generally not because it's closer, but because I can open my door wider, since the spot is wider and makes it easier for me to get in and out. That's why lots of people use them. But he was initially standing right on the line, and about 2 or 3 feet, I'd say, from the other line. So the driver, let's say 8 feet. So, whatever the hypotenuse of a 3 and 8 triangle is, he was about that distance away. And he moved about 2 feet further back the first time he was ordered back, and then refused to move again. So, you guys can do the math on that. Today I'm a lawyer, not a mathematician. So, yeah. So, legal standards, summary judgment, legal standard. A motion for summary judgment may be granted where there is no genuine issue as to any material fact, and the moving party is entitled to a judgment as a matter of law. That's Rule 56C and Celotex Corporation versus Catret. So, John Gibbons, it's because they're always spending their money on bail instead. Just not Delete Lawz, because no bail. And Judy, it's good to see you. We just started this part, so yeah. An issue is genuine. So remember, no genuine issue as to any material fact. So an issue is genuine if the evidence would permit a reasonable jury to return a verdict for the non-moving party. That's Soramikun versus Thrifty Payless, Inc., 9th Circuit, 2007. The substantive law will identify which facts are material. Only disputes over facts that might affect the outcome of the suit under the governing law will properly preclude the entry of summary judgment. Factual disputes that are irrelevant or unnecessary will not be counted. So here, factual disputes that are irrelevant or unnecessary will not be counted. So the First Amendment, hey, great. We love the First Amendment. But here, the First Amendment is irrelevant because this isn't an issue of filming. It's an issue of interfering. So basically, they're saying, yeah, hey, well, first of all, the First Amendment isn't a factual dispute. It's a legal principle. But good night, Gia. Thanks for sticking around as, this long. And that was Anderson versus Liberty Lobby, Supreme Court, 1986. A dispute is genuine only where a reasonable jury could find for the non-moving party. Conclusory statements, speculative opinions, pleading allegations, or other assertions uncorroborated by facts are insufficient to establish a genuine dispute. And that's Soramikun once again. So, hey, that's all he has. That's all he has is mostly conclusory statements and misstatements of the law. Well, there's also the speculative opinions that whole Monell, hey, they've got illegal practices and procedures, and I was a victim of them. Name those procedures. Name those policies. Well, I don't know what the policies are, but they have them. They have them. That's what we call speculation. This court analyzes summary judgment pursuant to a burden-shifting analysis. CEG, Green versus Samples. That's District of Nevada, 2022. The burden starts with the moving party. A party seeking summary judgment bears the initial responsibility of informing the court of the basis of its motion and identifying those portions of the pleadings, depositions, answers to interrogatories, and admissions on file, together with affidavits, if any, and other evidence which it believes demonstrate the absence of a genuine issue of material fact. That's from Celotex, once again. And that's it, Aniceto. That's what I mentioned at the beginning. He's pissed off that me didn't enter his video, but his video is worse for him. Officer Bork's body cam wasn't good for him, but his video is even worse because Officer Bork's video did show that he moved back a bit initially. But yeah. So when the non-moving party bears the burden of proving the claim or defense, the moving party can meet its burden in two ways. One, by presenting evidence to negate an essential element of the non-moving party's case, or two, by demonstrating that the non-moving party failed to make a showing sufficient to establish an element essential to that party's case, on which that party will bear the burden of proof at trial. If the moving party meets its initial burden of showing the absence of a material and triable issue of fact, the burden then moves to the opposing party, who must present significant probative evidence tending to support its claim or defense. That's Intel versus Hartford, 9th Circuit, 1991. The non-moving party cannot avoid summary judgment by relying solely on conclusory allegations that are unsupported by factual data. See Taylor versus List, 9th Circuit, 1989. So basically, it's, remember, so another case that we're going to hopefully get caught up on real soon is the TikTok psychic case, Schofield versus Giar. Remember the summary judgment motions there. We had the statement of undisputed facts. And it was, this fact helps us, Professor Schofield, and it's uncontested, and it comes from here. Ashley Giard did not respond to discovery. Therefore, this fact is taken as a admission. And so it can't be disputed. Well, here, what we're saying is, LVMPD is moving for a summary judgment. So here they're saying these are our facts, and they're supported by video evidence, both body camera and Delete Lawz. The video evidence is undisputed because all he has to counter that is conclusory statements, and those don't count. Those aren't, that they can't make the undisputed fact of the video evidence a disputed fact. So Delete Lawz just saying, yeah, I dispute that, doesn't make it a disputed fact. He has to bring something factual besides just his conclusory claim to say, this is why that element isn't met. That fact can't be taken as true at this stage. But here he can't. So that's what they're saying. That's the standard now. So Federal Rule of Civil Procedure 56D. Rule 56D provides a device for litigants to avoid summary judgment when they have not had sufficient time to develop affirmative evidence. So basically that's, hey, we haven't had sufficient time in discovery to figure out what the facts are. And that's something Delete Lawz has tried to argue, but LVMPD's going to say, hey, discovery's pretty much closed. We've done discovery. You're not going to find any more facts to counteract our motion. So 56D, you don't need more time. You've had sufficient time to develop affirmative evidence. And that was U.S. versus Kitsap Physician Services, Ninth Circuit 2002. Rule 56D permits a court to grant certain relief to the non-moving party when it shows by affidavit or declaration that, for specified reasons, it cannot present facts essential to justify its opposition of a motion for summary judgment. Rule 56, and that's Rule 56D. The court may, 1, defer considering the summary judgment motion or deny it. 2, allow time to obtain affidavits or declarations or to take discovery. Or 3, issue any other appropriate order. And that's, once again, Rule 56D, 1 through 3. A party seeking Rule 56D relief bears the burden of demonstrating that, 1, it has set forth in affidavit or declaration form the specific facts it hopes to elicit from further discovery. 2, the facts sought exist. And 3, the sought-after facts are essential to oppose summary judgment. That's Family Home and Financial Center versus Federal Home Loan Mortgage Corporation, Ninth Circuit 2008. And see also Tatum versus City and County of San Francisco, Ninth Circuit 2006, which says a party requesting a continuance pursuant to 56D must identify by affidavit or declaration the specific facts that further discovery would reveal and explain why those facts would preclude summary judgment. And legal argument. The body-worn camera footage has been sufficiently authenticated. So Delete Lawz was trying to argue, hey, we don't know if that body-worn camera footage is real. We don't know it's from my stop. We don't know that it hasn't been altered, tampered with, edited, whatever, even though, it's body-worn camera. Yeah. So Decastro contends in his opposition that there is insufficient evidence in the record to support the authenticity of the body-worn camera footage exhibits attached to the motion by defendants. Decastro disputes the authenticity of the body-worn camera footage on account of some of the officer declarations lacking signatures and because Decastro contends that the submitted video evidence could be clipped or excerpted to omit relevant evidence. With respect to the declarations of the 6 defendant officers, defendants acknowledged that at the time the motion was filed, not all of the officers had signed declarations authenticating the body-worn camera footage as demonstrated in Exhibit G to the motion. However, all 6 defendant officers have now signed declarations authenticating the body-worn camera footage attached to the motion, Exhibit I. And that's basically the exhibit I didn't pull up, but was in the, well, it'll be at the bottom of this document. So, and that's Exhibit I and supplement to declarations of defendant officers authenticating body-worn camera footage. Accordingly, Decastro's arguments based upon the lack of signatures on some of the declarations are now moot. Decastro also contends that declarations do not sufficiently authenticate the body-worn camera footage because not all of the declarations are dated. However, Decastro fails to explain why the lack of date on the declarations should have any bearing on whether the declarations successfully authenticate the body-worn camera evidence. Decastro does not cite to any law stating that dating a declaration is necessary for the purpose of authenticating evidence. Each of the declarations notes that the officers reviewed their own body-worn camera footage that was attached to defendant's motion and authenticates the footage. As a result, there is no reasonable argument that the lack of an exact date on which some of the declarations were signed would have any significance as to whether the defendant officers have reviewed and authenticated the body-worn camera attached to the motion. Lastly, Decastro suggests that although the body-worn camera footage does at least partially depict the events described in the complaint, Decastro cannot know if the videos are full and complete copies of the videos recorded by the defendant officers on the date of the incident. As noted above, the defendant officers have authenticated the body-worn camera footage themselves. In addition, defendants have previously provided the full set of body-worn camera footage relating to the subject incident to Decastro in their initial disclosures, dated November 16th, 2023. Come on, Glober Mom. Don't you know that bruises are a timey-wimey, wibbly-wobbly thing? That, you know, a pre-bruise is that clearly evidence of police brutality. It's, you know. Let's see. So, to the extent Decastro believes that any of the body-worn camera footage attached to the motion does not fully and accurately portray the relevant events, Decastro is in possession of the footage necessary to advance such an argument. It is also incumbent upon Decastro to argue with specificity why the body-worn camera exhibits lack authenticity. However, his opposition instead advances vague arguments about a theoretical possibility that the camera footage attached to the motion may not represent full copies or could omit relevant evidence. So, why didn't he bring up the nut punch in the criminal case? Well, number one, because it didn't happen. But number two, it wasn't relevant. It wasn't relevant. He had already interfered. He had already obstructed. And he had already resisted. So, after arrest conduct, you know, it would be relevant for civil lawsuits after the fact, but it wasn't relevant in the criminal case. I mean, we all know it's fantasy anyways, but it just wasn't relevant in the civil or in the criminal case. So, in light of Decastro's access to the relevant footage, his lack of any specific argument, and the defendant officer's declarations attesting to the authenticity of the footage, the court should find that the body-worn camera evidence attached to the motion is true and authentic evidence demonstrating what occurred during the subject incident. Decastro disputes the authenticity of the body-worn camera footage, and, as a result, the motion must be converted to one for summary judgment. In the motion, defendants requested that the court utilize the body-worn camera and Decastro's own YouTube video to determine whether Decastro stated claims upon which relief can be granted pursuant to a Rule 12b6 standard, and to determine whether the defendant officers are protected by qualified immunity. Defendants asked that the court consider the video evidence to be incorporated by reference into Decastro's second amended complaint. However, the incorporation by reference doctrine only permits a court to take into account documents whose contents are alleged in a complaint and whose authenticity no party questions, but which are not physically attached to the plaintiff's pleading. That's Knievel versus ESPN, 9th Circuit, 2005. And I assume that's Robbie Knievel, not Evil Knievel. Although 2005 Evil Knievel might have still been alive. I don't know when he died. So DCW production. Does Chili backing up 3 feet and not continuing to back up when asked to back up more show Chili was not obstructing? It's an excuse many of his fans are saying. No! Had he continued to back up, he wouldn't have obstructed. So basically, when the officer tells him to back up, either he could have told him back up 10 feet and then you're good. And then if he backed up 10 feet, he'd have been good. But when the officer gives an open-ended backup and then, he backs up a foot or two and the officer says, keep going, and he says no, that's when he obstructs. So I don't think it's a defense. Had he kept backing up, now that there is a point where, if he backs up 50 feet and the officer says, keep going, keep going, keep going, don't stop until you're in Lake Mead. Well, at some point, it becomes an unreasonable command. But when he's like 15 feet away, it's probably not unreasonable yet. So luckily for us, his fans are morons and they can be entertaining for us too. All right. Good to know, Robert Carley. Evil Knievel died in 2007. So this 2005 Ninth Circuit case could have been either one of them. But once again, I assume it's Robbie because I assume that's about the time period when he did his famous Grand Canyon jump. So, defendants did not anticipate Decastro would dispute the authenticity of the body-worn camera footage, given the fact Decastro has been in possession of the body-worn camera evidence for some time and has not expressed any doubts as to authenticity. Yeah, but he'll never agree to anything, so yeah. However, Decastro has advanced arguments in the opposition drawing into question the authenticity of the BWC evidence. As a result, the footage in the exhibits cannot be considered to be documents whose authenticity no party questions and is thus evidence outside of the Second Amended complaint. Based on the foregoing, defendant's motion ought to be considered a motion for summary judgment pursuant to Federal Rule of Civil Procedure 56. See Federal Rule of Civil Procedure 12B, which says, when ruling on a 12B6 motion to dismiss, if a district court considers evidence outside the pleadings, it must normally convert the 12B6 motion into a Rule 56 motion for summary judgment. And it must give the non-moving party an opportunity to respond. But here, they don't necessarily have to give them an opportunity to respond because the original motion was brought in the alternative, so they've already had an opportunity to respond to the Rule 56 summary judgment motion. So here, it's not so much converting from a 12B6 into a 56, it's converting from a 12B6 / Rule 56, dropping the 12B6 and only becoming only a Rule 56 summary judgment. So they don't necessarily need an opportunity to respond. But at this point, that's moot because, wrong tab, as I mentioned, this reply was filed February 9th. We are now April 3rd. So had they taken the opportunity to respond with a sir reply, well, they wouldn't have had 2 months to do so. So, what's the time frame for a surreply? 14 days, 21 days? I don't know. I don't care. It's certainly not 2 months. So that opportunity to reply or to respond has certainly passed. But despite Decastro's protests, it is not uncommon for this court to utilize body-worn camera evidence at the motion to dismiss stage and convert the motion into a summary judgment motion. See, e.g., Helmbrecht versus Henderson Police Department, District of Nevada, 2022. And that, yeah, he's too busy going under police tape and preparing for trials. So, to the extent the court does analyze the sufficiency of any of Decastro's claims pursuant to Federal Rule of Civil Procedure 12b6 standard, defendants request the court reject Decastro's repeated attempts to argue that notice pleading is the proper standard in federal court. Yeah, that's a problem for him because, well, so let's back up. So to the extent the court does use a 12b6 standard, so what that's saying is, hey, if the court doesn't need the body-worn camera to rule on some of the claims, you can still do it on the 12b6. It's just if you need the video, then you can't incorporate the video. You've got to do that as a summary judgment. But notice pleading. So basically, if you remember in the opposition, Delete Lawz and Michael Mee, they tried to say, well, we haven't given that, we haven't told them the facts other than our conclusory statements and, reciting the elements of the tort, of the claims. But that's enough that, we can tell them later. But our friends Twombly and Iqbal disagree. Notice pleading isn't enough. You've got to plead sufficient facts to survive the motion to dismiss. And he hasn't done that. So in Twombly and Iqbal, the U.S. Supreme Court introduced a heightened pleading standard that requires pleadings to go further than pleading only enough detail to put a defendant on notice of the claims and requires that plaintiffs plead factual allegations which, when taken as true, would be sufficient to entitle the plaintiff to relief. See Bell Atlantic versus Twombly, and see also Ashcroft versus Iqbal, both Supreme Court cases. And it's the fact that the opposition, where they said notice pleading is the proper standard in federal court, Michael Mee went to law school after I did. And I was taught in Twombly and Iqbal in my civil procedure class first semester of law school. So I can guarantee Michael Mee was as well. So like no lawyer in the United States has an excuse not to be familiar with Twombly and Iqbal. But a lawyer who's been practicing for 50 years, they might be in the habit of citing Conley versus Gibson, which was the standard before Twombly and Iqbal, when notice pleading was proper. It was sufficient. But even that geriatric lawyer has the duty to keep abreast of changes to case law. But Michael Mee has no excuse. He went to law school years after both of these cases were decided. So he has never practiced in a federal court where notice pleading is the proper standard. This is sanctionable. This is sanctionable. He, like, literally, he could be made to answer to the bar for this, because this isn't the standard of lawyering that the bar demands of us. It's embarrassing. Like, literally, this gives the impression that Michael Mee is a stain upon the legal profession. But, you know, if the Nevada bar is fine with him, whatever. I certainly wouldn't hire him. So, a plaintiff's obligation to provide the grounds of his entitlement to relief requires more than labels and conclusions, and a formulaic recitation of a cause of action's elements will not do. That's from Twombly, the earlier of the two cases. So, the problem, Glober Mom, is Michael Mee was a willing victim. He thought he could bask in the glow of Delete Lawz and not realizing he'd be burned. Just like Oram is going to suffer the same fate, even though he actually is a good attorney. I mean, look at it. He's been in a murder trial this, leading up to the April Fool's Day appearance. Michael Eline thinks he can hitch his wagon to Delete Lawz, and it's not going to help him. It's not going to help him. So, and Kevin Campbell, Lexus and Westlaw are expensive. They're very expensive. I only have the free service provided by the Utah Bar. Can't remember what it's called, and it's not nearly as good as Westlaw. But like I said, this isn't a matter of access to Westlaw and Lexus. It's a matter of actual competence as a lawyer, because these are foundational cases, Twombly and Iqbal. And like I said, they were taught in law school. He has no excuse. He has absolutely no excuse. Where was I? Okay. Decastro has failed to meet his burden of establishing that Rule 57D relief is warranted. So basically, Decastro has failed to show why the court should give him a chance for further discovery before ruling on the summary judgment motion. So Decastro argues summary adjudication of his claims would be premature and would deny him a reasonable opportunity to engage in discovery, and requests that the court deny the motion pursuant to Federal Rule of Civil Procedure 56D. Decastro contends that the court should deny defendant's request for summary judgment to allow for both parties to complete discovery, and because Decastro was representing himself in this matter until January 10th, 2024. As detailed herein, Decastro has not met his burden of demonstrating that Rule 56D relief is appropriate in this case. And Erica, he is attempting in the criminal case to do so, and I outlined before you got here why that's not going to happen. Me wasn't overwhelming, but he provided a competent defense, and frankly, I don't know that he could have done better with the facts that were available to him. So he's throwing me under the bus, but it's not gonna help. And that's it. I'm shocked, frankly, that me hasn't withdrawn as counsel in the civil case yet. It's you know, I will never find myself in this position because I'd be extremely reluctant to bring a civil case until after the criminal case is over because well, frankly, bringing the civil case, either you've got to admit things in discovery, or you've got adverse inferences against you, so you're not going to win the civil case, even if you actually would have had a shot otherwise. So, a good lawyer would actually wait to bring the civil case until after they win. But because Delete Lawz was representing himself in both cases in the beginning, he didn't do that. But the only way I'd bring a civil case beforehand would be if the statute of limitations forced my hand. So, yeah. And yes, the appeal, I believe, is in July. So, we'll see. He's not going to win it either way. Federal Rule of Procedure, Civil Procedure 56D provides a device for litigants to avoid summary judgment when they have not had sufficient time to develop affirmative evidence. That's U.S. versus Kitsap Physician Services, 9th Circuit, 2002. Rule 56D permits a court to grant certain relief to the non-moving party when it shows by affidavit or declaration that, for specified reasons, it cannot present facts essential to justify its opposition of a motion for summary judgment. The court may, 1, defer considering the summary judgment motion or deny it, 2, allow time to obtain affidavits or declarations or to take discovery, or 3, issue any other appropriate order. A party seeking Rule 56D relief bears the burden of demonstrating that, 1, it has set forth in affidavit or declaration form the specific facts it hopes to elicit from further discovery, 2, the facts sought exist, and 3, the sought-after facts are essential to oppose summary judgment. That's Family Home and Finance Center versus Federal Home Loan Mortgage Company. And see also Tatum versus San Francisco, 9th Circuit, 2006, which says a party requesting a continuance pursuant to 56D must, so not may, but must identify by affidavit or declaration the specific facts that further discovery would reveal and explain why those facts would preclude summary judgment. So remember way back when we did the opposition, they just said, hey, this is too early. This is too early. We haven't had a chance to do all discovery yet. But they must identify the specific facts that they think they'll be able to elicit. But they haven't. Or, well, they didn't. So, and that's it. He really did add him to delay. And even in the criminal case, it was a delay tactic, but the judge sussed that out because, when he tried to get me designated standby counsel the day before trial, Judge Zimmerman said, yeah, that's a delay tactic. We've delayed the trial multiple times already. Enough is enough. We're going today. And we're going with Mr. Me as counsel because, if I say, yeah, he's dismissed, but we're going today, then you're going to appeal and say, hey, I didn't have time to prepare for trial because blah, blah, blah. And that's just nonsense. So, and good to see you, Christo Kinerium. I hope I was close on your last name. So here, Decastro has not set forth an affidavit or declaration identifying the specific facts that he hopes to elicit from further discovery, demonstrated that such facts exist, or explained how the sought-after facts are essential to a post-summary judgment. He didn't even mention in the motion or in the opposition to the motion. So it's not just that they didn't do the affidavit or declaration. They didn't even say in the opposition motion what facts they think they'll be able to elicit. They just said, yeah, no, we need more time. We need more discovery. But it doesn't work that way. And it really is hilarious that he thinks he's out the minute that the appeals brief is filed. He's out. He's going to have a bad time. He's going to have a bad time. And Mr. Shobart, yeah, that was hilarious in his arraignment with the other judge. And she's just nodding along like, yeah, sure you are, champ. Just not even arguing, not playing into it, but just, yeah, sure you are. Sure you are. And Floyd Wallace was dropped like a, he was gone as soon as he became a liability to the Delete Lawz. He was gone. He's in Brazil, I think. He's a moron. Like, actual moron. Decastro's claims are all predicated upon the subject incident, and the best evidence of the subject incident is the body-worn camera evidence, which was disclosed to Decastro months ago. Although Decastro's counsel only appeared in the case 1 month ago, he has had sufficient time to familiarize himself with Decastro's claims and the body-worn camera evidence and other disclosed evidence, such that he should be able to offer some kind of explanation as to what discoverable information he believes to exist, which would be essential to opposing summary judgment. Besides which, the body-worn camera would have been provided even before that in the criminal case. So, and Michael Mee, while at the time of this motion had only been on the case for a month, he'd been on the criminal case longer than that. So he's had the evidence because there was discovery in that case as well. Now, admittedly, it's not all the discovery that Delete Lawz wanted because, he wanted the officers' birth certificates, I'm sure, and their marriage licenses and their, third grade teacher's, pet goldfish name. You can't get all that because it's not relevant, but he wanted it all. He wanted everything. But he had the body-worn camera footage as evidence ages ago in both cases. And it would have been unredacted if he got it through discovery as opposed to the version that's on YouTube that Artie's Corporate Fiction got through a FOIA request, because FOIA requests, you redact certain things, whereas he would have had the whole thing. And he would have had, presumably, the entire traffic stop as well, with Jane Doe, the driver of the Hyundai. So, and in fact, that was shown in the criminal trial. So, So, however, Decastro cannot point to any such discoverable information in this case because there is no evidence that could overcome what the body-worn camera evidence plainly demonstrates. The bottom line is that the subject incident is the basis for Decastro's claims, and the body-worn camera evidence explicitly captures the subject incident and allows the court to make an accurate determination as to whether any of Decastro's claims should survive summary judgment. Crucially, Decastro has made no effort to meet his burden of establishing that Rule 56D relief is warranted. Based on the foregoing, the court should deny Decastro's request to deny the motion based upon Rule 56D. Next up, summary judgment is warranted on all of Decastro's 42 USC Section 1983 claims. So they're saying, hey, all of the civil rights claims, summary judgment is warranted. So the motion unambiguously, and that's the summary judgment motion, unambiguously set forth a statement of facts based on the body-worn camera evidence and argued that the body-worn camera evidence demonstrates that Decastro failed to state viable claims, or, in the alternative, that defendants are entitled to summary judgment as a matter of law. And yes, lying under oath is a big no-no. It's not a mere whoopsie-doodle, it is a crime called perjury. In responding to defendants' legal arguments, however, Decastro's opposition generally addresses defendants' substantive legal arguments only pursuant to a motion to dismiss standard, relying on the allegations of the second amended complaint and wholly ignoring the facts adduced in the body-worn camera footage. In doing so, Decastro's opposition fails to point to any evidence which could establish a genuine dispute of material fact, precluding summary judgment as to any of Decastro's claims. Accordingly, the court should consider the body-worn camera evidence and grant summary judgment in favor of defendants on all of Decastro's 42 USC Section 1983 claims. Decastro's Fourth Amendment excessive force claim fails as a matter of law, and that's the third cause of action. And so for his legal document business, the problem is his trifold is damaging. It damages the morons who buy it and use it. It puts them in jail. The problem is it's not the unauthorized practice of law, because one of the elements of the practice of law is tailored legal advice. So it's, you know, if someone were to buy the trifold from him and say, which of these cases fits my situation, and he points to it and says, use that one, that would be tailored to them, and it would be the unauthorized practice of law. Selling the trifold, well, it's a scummy thing. It's completely wrong, the legal advice in it, and, you know, certain discarded former assistants need to stop selling it as well, because it's a scumbag thing to sell things with bad legal advice. But yeah, and he probably did give tailored legal advice to Floyd. The problem is Floyd's not going to admit it himself, and frankly, he'd have to be the one that goes to the bar and complains. You know, Mr. Craig Anderson, who, you know, he was the defense attorney on the Floyd case, you know, can go to the bar and say, hey, you should really look into this Jose Decastro guy. I think he was writing the motions for the Floyd Wallace case. Well, Delete Lawz can say, well, yeah, it looks almost identical to mine, but that's because Floyd copied it. He downloaded my document off of Pacer and he copied it, and that's what he submitted to the court. He did it himself. If Floyd were to say, that scumbag gave me bad advice and he wrote my motions for me and he was using me, then, so it's a complicated thing. So But yeah, so the Fourth Amendment excessive force claim fails as a matter of law. Defendants hereby incorporate the legal standards and arguments set forth in the motion with respect to excessive force. In his opposition, Decastro contends that the video evidence is not dispositive because the video evidence is not clear or detailed enough, and that whether the pat-down was a routine pat-down or a retaliatory strike, and whether Decastro's arm was squeezed unreasonably tightly are matters for the jury. Decastro also relies on his own self-serving allegations in the Second Amended complaint in attempting to argue against summary judgment. Decastro's arguments misstate what the video evidence shows and misunderstand the summary judgment standard. Oof. The video evidence is clear and sufficiently detailed. Defendants have met their burden on summary judgment by establishing through the body-worn camera evidence that 1. Decastro was actively resisting the defendant officers despite their having probable cause to arrest him. 2. No defendant officer made contact with Decastro's groin area absent an objectively reasonable pat-down. And 3, Officer Sandoval's use of force in maintaining a grip on Decastro's arm due to his continued resistance after handcuffing and on account of the defendant officer's concern that Decastro would fall and injure himself was objectively reasonable under the circumstances. True. Because defendants have met their burden of identifying evidence which demonstrates the absence of a genuine issue of material fact, the burden shifted to Decastro to present significant probative evidence tending to support his excessive force claim. Decastro has not done so, instead relying on preposterous interpretations of the body-worn camera evidence and his own self-serving allegations in the Second Amended complaint. Preposterous interpretations and conclusory statements. Decastro's suggestion that the body-worn camera evidence is open to multiple interpretations does not create a genuine issue precluding summary judgment because no reasonable jury could determine that the defendant officers used excessive force on Decastro based upon the events depicted in the body-worn camera footage. Based on the foregoing, no Fourth Amendment excessive force violation occurred, and the defendant officers are entitled to summary judgment on Decastro's excessive force claim. Lastly, Decastro has failed to identify any clearly established law that would prohibit the defendant officers from using the force which Decastro complains of in connection with the subject incident. Decastro has not advanced any argument in the opposition that the defendant officers violated any clearly established law. And here the court could rule that, hey, the officers did act unreasonably, but it has to be clearly established law for them to be held accountable. So if the court says, yeah, you can't hold on to his arm, that's completely unreasonable. Now future officers would be on notice. But they're not in this case. Now, the court isn't going to hold that because it's completely reasonable for the officers to hold on to the arm of a handcuffed, detained, or in this case, arrested subject because it's a safety issue. If you've got your arms handcuffed behind your back, if you fall, you can't catch yourself. So it's objectively reasonable. In fact, it would probably be unreasonable for them not to be holding on to his arm. Or alternatively, it would be reasonable for them to have him take a seat. You know, those are the reasonable options, not, hey, just, hang out with your, arms handcuffed behind your back, hang out. If you fall, that's on you. You shouldn't be clumsy. But, and that's it, Pat's Cats. He continued to struggle when he was handcuffed. So if he was injured because of, them holding onto his arm, it wasn't because they were holding him. It was because he was struggling while they held him. His struggling was not reasonable. So, yeah. The failure of an opposing party to file points and authorities in response to any motion constitutes a consent to the granting of the motion. That's District of Nevada Local Rule 7-2D. See also Danielson versus Stratosphere, District of Nevada 2011, which dismissed a plaintiff's claims where a defendant failed to respond to certain of defendant's arguments. As a result, the defendant officers are entitled to a finding of qualified immunity on Decastro's excessive force claim. And Fletcher boy, thank you very much. And late is better than, better late than never. And of course, you're free to watch whenever. I mean, yeah. And I realize, there's other people live. I mentioned I postponed by half an hour because I saw Artie was arguing with morons and didn't want to conflict with that. But then, KFAR went live half an hour after I did. So, Wednesday night tends to be busy, we'll just say that. But yeah, I'm glad you're here now, though. And thank you. So, for the foregoing reasons, the court should grant summary judgment in favor of defendants on Decastro's excessive force claim. Decastro's First Amendment retaliation and selective enforcement claims also fail, and that's the 5th, 6th, and 8th causes of action. Defendants hereby incorporate the legal standards and arguments set forth in the motion with respect to Decastro's First Amendment retaliation and selective enforcement claims. In the motion, defendants set forth the applicable law set forth by the U.S. Supreme Court in Neves for Decastro's First Amendment retaliation and selective enforcement claims, which noted that an arrest supported by probable cause can only be considered retaliatory when similarly situated individuals engaged in the same sort of protected speech were not arrested. That's citing Neves versus Bartlett, Supreme Court, 2019. This court has already correctly determined that the arrest of Decastro was supported by probable cause. And now it's not just supported by probable cause, it's beyond reasonable doubt. He's convicted. But at the time, it was just supported by probable cause, as had already been ruled by the federal court. So it is thus Decastro's burden to plead and present evidence that similarly situated individuals, namely individuals interfering in traffic stops and refusing to move when commanded to do so, were not arrested for obstruction. Decastro has not pled such facts in the Second Amended complaint, nor has he presented any evidence in his opposition to support such a theory. And here, he in fact, his own similarly situated conduct, he was arrested again for going on the scene of an admittedly much more serious police interaction, a fatal car crash, but ducking under police tape and refusing to leave and being arrested. And once again, neither of them were for the camera. They were for interfering, for being on the scene. And that's it. I can't find any First Amendment case rulings to support his. It's because it's not a First Amendment issue. It's an interference issue. The camera is not a shield. It's not a shield. Not a shield. And thank you very much, Mr. Shobar. I really do appreciate it. So, Decastro has not pled such facts in the second amended complaint, nor has he presented any evidence in his opposition to support such a theory. I think I already read that sentence, but better safe than sorry. Decastro asserts in his opposition that he denies that he illegally interfered with any traffic stop for the reasons alleged in the second amended complaint. However, the court has already determined that the defendant officers had probable cause to arrest Decastro for doing just that. Decastro's insistence that he did not is irrelevant, especially in light of the body-worn camera evidence, and now in light of his conviction. His conviction. Decastro further argues that to the extent defendants ordered Decastro to move back or stop filming, such orders would be unlawful orders. However, Decastro's attempts to incorrectly inflate an order to move back from the traffic stop with an order to stop filming are unavailing. And that's a bad use of word. It should have been conflate instead of inflate, although as Delete Lawz tends to bloviate, the hot air would have a tendency to inflate. Thank you. I'm here all night. The body-worn camera evidence clearly establishes that the defendant officers never told Decastro that he could not film. Bork did, however, repeatedly issue orders to Decastro to move back and film from a reasonable distance so as to allow Officer Bork room to safely conduct the traffic stop without interference. Decastro refused to do so. And once again, Officer Bork told him, "I have no problem with you filming." He was told he could do so. He just had to move back and not engage with the driver, of course. Decastro also argues that other citizens walked near the investigation scene during the traffic stop. The body-worn camera evidence does not show other citizens approach the detained driver during the pendency of the traffic stop. The citizens who did approach the defendant officers while they were arresting and holding Decastro were not standing in the middle of the scene and refusing to leave, and accordingly could not be reasonably considered to be similarly situated to Decastro. Once again, not only did they not refuse to leave, they were inquiring, "Hey, is it okay if I go into the business? Can I go to Roll and Smoke, or are you blocking that off?" So they weren't attempting to enter the scene. They were making sure that they weren't. They were checking with the officers to make sure that they were not interfering. So they were not only not similarly situated to Delete Lawz, they were the complete reverse. Delete Lawz intentionally interfering, The others intentionally not interfering, making sure that they were fine. Well, the 25 grand wasn't for the bail hearing, it's for the appeal, which is in July. So I'm sure, though, as soon as they lose, well, some of them are already throwing Mr. Oram under the bus for not getting him out of jail, but you know, they're not going to be happy in July when he loses the appeal. But and yeah, the 2 GoFundMe's they're at 40K. As I've said, it would be a lot more lucrative for me if I were a degenerate scumbag, because I like it. I could do the, much as Delete Lawz hates the guy, but lackluster Dale, reviewing auditors and yeah, this is where the cops screwed up here. Except I'd be lying, and I'm not a degenerate scumbag. I'm just a degenerate lawyer. But it would be a lot more lucrative for me. And one of Delete Lawz GoFundMe's is for legal fees, all funds go to lawyers. And I'm like, I should do that same GoFundMe and just pay it to myself, because it's not fraud, because hey, all money goes to this lawyer. But I'm not a degenerate scumbag. So I do appreciate all the support. Don't get me wrong. I do appreciate the support. But it would be a lot more lucrative if I were grifting off of dumbasses. That's all I'm saying. And that's it. The 25,000 was the retainer for the appeal. That hearing that we watched was probably between 500 and 1,000, depending. I don't know what Mr. Oram's rate is. Yeah. And that's it. Am I really a YouTuber until I become a degenerate grifter? Or, although there is a decent enough section of YouTube calling out degenerate grifters. But yeah. But moving on. In sum, defendants have met their burden at summary judgment on account of the fact that the defendant officers had probable cause to arrest Decastro, and by pointing to Decastro's complete lack of admissible evidence that similarly situated individuals in the past had been treated differently. Decastro has neither alleged nor presented evidence of the existence of any individual who engaged in substantially similar conduct and was not arrested for obstruction. Decastro's reliance on his own self-serving allegations do not create a genuine issue of material fact. The evidence indicates that the defendant officers did not arrest Decastro for retaliatory reasons, nor did they selectively enforce the Nevada's obstruction statute against him. As a result, the court should grant summary judgment in favor of defendants on Decastro's retaliation and selective enforcement claims. So, Decastro's failure to intervene claim fails, and that's the 12th cause of action. So, and that's it. Oram, by all accounts, he's a good attorney. Like I said, he's in a murder trial. I don't know if he's appointed counsel or retained counsel, but he's death penalty qualified. So that means the state can appoint him as a public defender in a death penalty case. You've got to be at least a decent lawyer and very experienced in order to be death penalty qualified. I'm not death penalty qualified, but I don't understand why he's willing to make these frivolous arguments, unless he actually believes that the First Amendment is a shield to, that allows you to interfere in traffic stops. But I certainly wouldn't put my reputation on the line for that. So defendants hereby incorporate the legal standards and arguments set forth in the motion pertaining to Decastro's failure to intervene claim. As noted in the motion, the Ninth Circuit has only recognized a claim for failing to intervene in the excessive force context. Police officers do not have a general duty to intervene in all alleged wrongdoings by a fellow officer. That's Briscoe versus Madrid, Eastern District of California, 2018, and Dental versus City of Salem, District of Oregon, 2015. For the reasons discussed above, the video evidence shows that, as a matter of law, the defendant officers did not use excessive force against Decastro. Therefore, Decastro's failure to intervene claim fails as a matter of law, and the court should grant summary judgment in defendant's favor. And it could just be that Orem likes $25,000. He knows he's going to lose. He's going to craft an argument that, he knows he can't win. He knows it's futile, but craft it in a way that it's not frivolous. That's going to be the hard work part. But it could be he just likes $25,000. I like $25,000. Summary judgment is warranted on Decastro's Monell claims. Defendants hereby incorporate the legal standards and arguments set forth in the motion with respect to Decastro's Monell causes of action. In the motion, defendants argued that Decastro failed to properly plead a Monell claim because he merely pled a conclusory wish list of unconstitutional policies, customs, and practices relating to LVMPD's methods of effectuating arrests, searches, and seizures, hiring and training practices, and more. It wasn't even a conclusory wish list. It was just a recitation of what a Monell claim could be constituted of. It was literally, he was quoting Monell and saying, yeah, this is what they're doing. I don't have any evidence, but see, they quoted this in Monell, and that's what they're doing. These are the Monell officers, basically. But no evidence. Not even tailored conclusions. It was just a list. It doesn't even come close to stating a claim upon which relief can be granted. But, because the law requires identification of a policy that, when enforced, caused the alleged constitutional violation, and the only policies identified by Decastro that are not conclusory and intended to recite the elements of the claim are policies which would uphold the constitutional rights of the citizenry, the claim should fail as a matter of law. Yeah, I forgot about that. I forgot, because he did list some policies, but it was like legitimately it was helpful to LVMPD, the policies he listed. Now, if he were to say, yeah, these are their policies, but boy, oh boy, do they not follow them. And so it's an unofficial custom for them to disregard these official policies. But he didn't even do that. It was just, these are their policies, and these are the Monell factors, and therefore, Monell claim. Give me money. Give me 7 figures. But it doesn't work that way. Conclusions without facts is a fail, unless you're Captain Conclusory. Because if you're Captain Conclusory, conclusions are all you've got. In opposition, Decastro argues that his conclusory allegations intended to recite the elements of a Monell claim are sufficient. They are not. They're not. Moreover, considering the instant motion has been converted to one for summary judgment, defendants have met their burden by demonstrating that Decastro cannot make a sufficient showing to establish an element essential to his Monell claim, the existence of an unconstitutional policy, custom, or practice. Decastro's reliance on his conclusory allegations of unconstitutional policies is insufficient to establish a genuine issue of material fact. As analyzed above, Decastro has also not met his burden of establishing that Rule 56D relief is appropriate. As a result, the court should grant summary judgment in favor of defendant LVMPD on Decastro's 42 U.S.C. Section 1983 Monell causes of action. And I agree. And I also agree with Kevin Campbell that Chad should give me a thumbs up, but the rest of you should give me a thumbs up too. And, you know, I usually forget until the very end of the video, but, you know, like, share, subscribe, do all of that while you're at it. Bribe your friends and family to do the same. So, summary judgment is warranted on all of Decastro's state law claims. Decastro's defamation claim fails as a matter of law. That's the 4th cause of action. Defendants hereby incorporate the legal standards and arguments set forth in the motion with respect to Decastro's defamation claim. Decastro apparently agrees with defendants as to the relevant legal standards for a defamation cause of action in Nevada, where a plaintiff alleges that police officers defamed the plaintiff through a police report. In opposing the motion, Decastro does not dispute that the second amended complaint fails to allege any facts demonstrating publication of the allegedly false police reports to a third person in the absence of privilege. Luckily, we're getting close to the end because I'm starting to stumble over my words almost as much as I stumble over steps. Decastro's conclusory allegations intended to recite the elements of a defamation claim within the second amended complaint are not sufficient. Considering that the instant motion has been converted to one for summary judgment, defendants have met their burden by pointing to Decastro's complete lack of evidence which could establish a single element essential to his defamation claim. Decastro's reliance on his own self-serving conclusory allegations of defamation is insufficient to establish a genuine issue of material fact. As a result, the court should grant summary judgment in favor of defendants on Decastro's defamation cause of action. And Vera Lucia Campos, thank you very much. I always appreciate your support. And that is most likely a true statement. He's at least a limited public figure. He's a public figure to anyone that this defamation would matter to. So he's admitted in other places that he is a public figure. So yeah. Decastro's battery claims fail as a matter of law, and that's the 9th cause of action. Defendants hereby incorporate the legal standards and arguments set forth in the motion pertaining to the battery claim. In the motion, defendants argued that because the standard for battery under Nevada law by a police officer is identical to the analysis of a 42 U.S.C. Section 1983 claim, and Decastro's excessive force claims fail as a matter of law, the battery claim must also fail. In opposition, Decastro does not dispute the applicable legal standard, but argues that the excessive force claim has been validly pled. But nuh-uh, Your Honor, isn't a valid legal argument. Decastro also contends that defendant's motion with respect to the excessive force issues should be denied because defendants did not address Decastro's claim that defendants intentionally battered him while placing him in the police car. The body-worn camera evidence provided by defendants clearly demonstrates that the defendant officers did not use excessive force in placing Decastro into the police vehicle. Accordingly, as with Decastro's other theories of how the defendant officers used excessive force against him, defendants have met their burden of identifying evidence which demonstrates the absence of a genuine issue of material fact with respect to the theory that the defendant officers used excessive force in placing Decastro into the police vehicle. So this associate is a very good legal writer, but his sentences go on much longer than my lung capacity. I've got a complaint about that. So as a result, the burden shifts to Decastro to present significant probative evidence tending to support his battery claim. Decastro has not done so, instead relying on his own self-serving allegations in the second amended complaint. No reasonable jury could determine that the defendant officers used any excessive force on Decastro based upon the events depicted in the body-worn camera footage. Based on the foregoing, the defendant officers did not commit a battery against Decastro, and the defendant officers are entitled to summary judgment on Decastro's battery claim. Next up, Decastro's negligence claim fails as a matter of law. That's the 11th cause of action. Defendants hereby incorporate the legal standards and arguments set forth in the motion regarding Decastro's negligence claim. In the motion, defendants argued that Decastro's claims that the defendant officers committed intentional constitutional torts against him are inconsistent with a claim for negligence. In opposition, Decastro contends that he has pled claims for negligence that do not rely on a theory of excessive force or other intentional conduct. Defendants first note that the court has previously dismissed with prejudice Decastro's negligence claim based upon the arrest and search, dismissed without prejudice his negligence claim based upon biased policing, and left open his ability to assert a negligence claim based upon excessive force. Decastro has not pled in the second amended complaint facts which would indicate any negligent conduct by defendants. Moreover, in the summary judgment context, Decastro has failed to identify a legally recognized standard of care or evidence indicating a breach of any recognized standard of care. With negligence, remember, the elements are there has to be a duty of care owed and a breach of that duty. Here, Decastro hasn't shown either of those. Decastro has not met his burden to establish a genuine issue of material fact that the defendant officers breached any legally recognized standard of care. Conclusory assertions within the second amended complaint are insufficient to create such a genuine issue, and the court should grant summary judgment on the negligence claim in favor of defendants. And next up, let's see. This is probably the last one because we're 16 of 18. Decastro's civil conspiracy claim fails as a matter of law. 13th cause of action. Remember, it's never RICO, even in, well, especially in the civil case. It's never RICO, except in the rare occasion that it is RICO. But with Delete Lawz, it's never RICO. Defendants hereby incorporate the legal standards and arguments set forth in the motion relating to Decastro's civil conspiracy claim. In the motion, defendants cite to law establishing that the party alleging civil conspiracy must plead detailed descriptions of the time, place, and identities of the parties involved in the conspiracy. That's citing to Brown versus Keller, Nevada Supreme Court, 1981. And that's it. It's never lupus either, except in the rare occasion that it is. In opposition, Decastro relies on the conclusory allegations within the second amended complaint intended to recite the elements of the claim. Such conclusory assertions do not sufficiently plead detailed descriptions regarding the conspiracy, nor that the defendant officers acted with the purpose of specifically harming Decastro. Because Decastro has failed to allege that the defendants intended to accomplish some unlawful objective for the purpose of harming him, he has failed to state a claim upon which relief can be granted for civil conspiracy. Moreover, in the summary judgment context, defendants have pointed to Decastro's failure to make a showing sufficient to establish an essential element of his civil conspiracy claim. Decastro has failed to set forth evidence which would establish a genuine issue of material fact. Accordingly, the court should grant summary judgment in favor of defendants on Decastro's civil conspiracy claim. Oh, I guess there's at least one more cause of action. Decastro's abuse of process claim fails as a matter of law. 14th cause of action. And it especially fails now because they're going to say, hey, the abusive process isn't right because, you know, in order to even bring an abusive process claim, the abusive claim has to have been dismissed already. You have to have won. You have to prevail on that. But he hasn't. Well, now he's already lost. He has been convicted. So abusive process, it can't be abusive process if you're convicted of that process, of that claim. So this one doubly fails now. So, yeah. And that, Judy, you got this? Apparently his claims of baloney and whatever else aren't even on the menu. Peanut butter isn't on the menu because, you know, there are people allergic to peanut butter and you don't want allergies in a prison. You don't want fatal allergens in a prison. So, defendants hereby incorporate the legal standards and arguments set forth in the motion regarding Decastro's abusive process claim. In the motion, defendants provided the relevant elements of an abusive process claim and explained how Decastro's pleadings were wholly insufficient to successfully state a claim because Decastro does not identify in the second amended complaint a willful act in the use of the legal process against him after the filing of criminal charges. In opposition, Decastro merely argues that he has met the notice pleading standard. But once again, it wasn't right. You have to have prevailed. So federal courts do not recognize a notice pleading standard. See Twombly and Iqbal. And Decastro has neither alleged nor offered evidence to support an essential element of his abusive process claim. As a result, the court should grant summary judgment on the claim in favor of defendants. And once again, that claim doubly fails now because he's been convicted. So, conclusion, based upon the above, the defendants respectfully request that this court grant summary judgment on Decastro's claims in favor of defendants. Dated this 9th day of February, 2024, Markey Auerbach, signed by Craig R. Anderson, and it was served and blah, blah, blah. And so The rest is the exhibits. So we've got the new declarations and yeah. So that's that one. And then finally, as I mentioned, we have the order denying the motion to recuse, because remember, Delete Lawz way back in the mists of time tried to get the judge off the case because you ruled against me, so therefore you're biased. And the judge said, no, you. So this is the order denying the motion, and it's recent. It was a week ago, I think. So Plaintiff Jose Decastro moves for me, the judge, to recuse myself from this case under 28 U.S.C. Section 455A because he contends that I am biased. The defendants oppose. And you'll notice that the judge pretty much gives the same reasons that everyone else gave for why the motion had to fail. So subsection 455A requires a recusal when a reasonable person with knowledge of all the facts would conclude that the judge's impartiality might reasonably be questioned. That's U.S. v. Studley, 9th Circuit, 1986. How would that be to have the last name Studley? Yeah, I'm Joe Studley. The reasonable person is not someone who is hypersensitive or unduly suspicious. So basically, Delete Lawz is not a reasonable person because he is hypersensitive and unduly suspicious. That's U.S. versus Holland, 9th Circuit, 2008. Prior judicial rulings alone almost never constitute a valid basis for a bias or partiality motion unless they display a deep-seated favoritism or antagonism that would make fair judgment impossible. And that's Leichty versus U.S., Supreme Court, 1994. So basically, there has to be some extrinsic reason. It can't be, you ruled against me, therefore you're biased, therefore get the hell off my case. It's, I ruled against you because your arguments were terrible. The other side made better arguments. So Decastro relies only on my rulings in this case, but my rulings do not reflect a deep-seated bias against Decastro or his case. I therefore deny his motion to recuse. I therefore order that Plaintiff Jose Decastro's motion to recuse, ECF number 50, is denied. Dated this 29th day of March, 2024, Andrew P. Gordon, United States District Judge. So short and sweet. That one was, it was easy peasy. So there we are. So look at that. Going back to the docket, we are officially caught up on this case. So yay. I don't remember if he officially, I don't think he officially did a motion for Judge Burroughs to recuse in the Massachusetts case. He just did the sugar tits motion, basically, give me all this information that I'm not entitled to. And I think he was going to use that information to try to get her to recuse herself. So I think he wasn't entitled to it. I don't remember if she even responded, but in Nevada, he skipped the sugar tits motion and just went straight to the recusal. And let's see. Find Decastro versus Abrams on this list. And we'll do Control F. And so searching for motion to recuse, I don't see one. And so, yeah. And I mean, Judge Doro did everything she could to give Daryl Brooks a fair trial. And so I'm hoping, I'm really hoping that new sovereign citizen that was arrested and featured yesterday on Law Talk with Mike, with the crazy eyes in Washington County, Indiana, who her dead son was found in a suitcase. I'm really hoping that goes to trial and is streamed. Like, I think we need to maybe start petitioning Court TV or Law and Crime to, put cameras in that courtroom, or, convince Alex from our Nevada judges that he should put in a request and, put in the time to go film that. Because if she's representing herself and she's got the crazy eyes, I think that one could be wild. Like, I really want to do that trial. But as I mentioned at the beginning, it looks like I should be able to do the Karen Reed trial. You'll notice I haven't covered any of the Karen Reed litigation up to this point, and that's kind of because if I'm thinking I want to do a trial, I tend to not follow it too closely beforehand, because I want to go in as a pseudo juror. So that's basically where I am on that. But I think I'm going to do it. I haven't committed yet, but I want to. So yeah, but I think that's where I'm going to leave you. You should be impressed because I kept it under 3 hours, and I didn't think I'd be able to. So you should be very impressed by that. And yeah, so thanks for joining me. This was a fun one. We're caught up, and hopefully we will soon be caught up on both the Janet lawsuit and the TikTok psychic lawsuit and all that fun stuff. And then we can get into more shenanigans as well. But either way, thanks for joining me. It's been fun. I will see you all very soon. Like, share, subscribe on your way out. And yeah, bye-bye.